Newman said, we are opposed to the portion of the bill that changes the standard from what is best for children to what is fair to parents. I have my testimony, you have my testimony, and I think so many good questions have been raised that I'm going to really leap through it and then be available for questions or try to answer them if I think I could maybe contribute to some of the questions, the good questions that have been asked. Our primary problem with this, though, is the section 4. And in that part, you talk about equitable, it will be an equitable division of the children, equitable and reasonable. And you cannot divide a child equitably. You can divide cattle and bank accounts and bills and debts and furniture, but in a divorce, but you cannot equitably divide children. The standard is what is best for our children, the children that are before the court, not what is fair to the parents. The parents had their childhood. They are now in a position where they have children who are going through a really difficult time, and the courts have always looked at what is best for the children. One session ago, you all spruced up those standards that are applied to figure out what the best interest is and modernized them a little bit and added things like we'll look at the developmental needs of the children. We'll look at which parent is going to best foster a relationship with the other parent. We look at the extended family. We look at who could best provide the child with stability, who can best provide the child with guidance. We look at morality as it affects the child, or conduct as it affects the child, and health as it affects the child. So the standard has been the best interest of the child, and what this law will infuse into it is, as Bill said, is confusion, because we have both the equitable distribution of the children as well as the best interest standard, but there's no place in the formula any longer under this for the best interest of the child. So I have examples in here of different family situations, how they could be resolved by the best interest. We would consider a child's preference. We would consider that one parent has been very heavily involved in their care, and the other parent, whether through choice or like the witness who may be gone now, who talked about how hard he works. He was not there, and the court can consider that in making what's going to happen to this child in the future and look at all those factors. Under equitable, when we look at equitable in family law and in divorce, what we look at are what are called the Roth-Fisher factors. They apply to property. What's the income producing ability of the people? What does that asset produce? How long have you been married? Where did the asset come from? These are not principles that apply in any way, shape, or form to what should be done for children. This legislature has done many, many things to improve the situation. And yet, of course, it remains to be difficult. I wasn't sure when I prepared to come here whether we were talking about equal custody, cloaked in another name of equitable, or whether we were actually talking about some other animal. I'm still not sure, because I think some of the witnesses talked about equal time. Mr. Fleck talked about a 35% presumption. So I'm still not sure. I do have additional testimony that I didn't prepare enough on equal custody. And the reason I'd like to at least give it to the clerk or have it available to you is because it talks about studies that have been done in other places. For example, in Australia. Australia was confounded by this. What should we do with our kids? Do they have to be 50-50? Should they be 50-50? What are we going to do? And they found that, and so they did a really big, extensive study of people and kids and how they were coming through these things. And that's quoted in here, but no small part of it says that children who are under the age of 4 and 5, even if you have good, healthy, supportive family relationships and people who don't hate each other, and can get along, that those children have trouble, and it shows up in all kinds of ways because they don't have the concept, the developmental concept of permanence. They can't imagine that they'll see mom again or dad again. So these arrangements don't work as well for them. But for older children, it found sometimes it works, sometimes it doesn't, and it's the equal custody idea. And that depends on, not surprisingly, the way the parents behave, the way they behave after this has gone into effect. If they continue to quarrel and squabble and pull the children from here to here and back again, then those children, not surprisingly, again, do not fare well. So there's some information in here that I would like to be able to give the caregiver wants it. Can I give it to you to pass on? Thank you. And that's on equal custody, just because it may or may not be at play, I don't know. I think the problem with any kind of cookie cutter formula, you will have 50-50, you will have 35%, is it doesn't accommodate the individual needs of the family who's before the court. And when we are looking at custody, parental responsibility, that's what we want to do. But there are, and so now I'd like to just jump into the questions, because I just can hardly stand to sit there and not answer. Gender bias, you know, the statute, I think you pointed it out, because it's in here where we won't favor mother or father. That's been there for a long time, because it used to be that we did favor mother. It's called the tender years doctrine, the mother's got to have custody of little kids. But I take lots and lots and lots of dads through this process, and many, many, many of the fathers come out of it with either custody or equal time, and that's a decision that they make with their spouse, and at times it is through the court process. I would almost rather, if I want to just worry about winning, take a dad to court than a mom. Two good parents, because I think that we just have changed a lot in how it gets there. What I always think we need to recognize with mothers and fathers is that long before they hit my office, they have made choices that make one or the other of them a better solution for the children. Lots and lots and lots of women still take the lion's share of the responsibility for children in the home while the family's intact. They are more likely to be paying attention to those kind of details. It's just still the way we are. So when they walk into my office or go into that courtroom, they already have a bucket of stuff to talk about that has been allocated to mom. Mom is more experienced at this. Mom is more used to doing that. The kids are used to turning to her. Her work schedule is more accommodating than dad. It's just the way many people live their lives. So when you see imbalance in how the decisions come out, it's more often because the choice was made a long time ago by the people who are in the courtroom than it is because of something the judge does because he thinks or she thinks that there is bias in the court, and there should be. So I honestly, I don't see it. Now you may think that's because I'm a woman and a mother, old kids, but I just don't see it, not in this arena. I'd like to talk about some of the solutions that there are for some of the problems that have been raised here, and I'll freely admit to you that there is not always a cheap and easy way to get your problem solved in this system. There just aren't. Maybe it's more parenting coordinators. That would certainly help for some families, especially the ones who have the ongoing, like Miss Barbie, I think her name was Barbie, Miss Barbie seems to have had. That may be a better solution for those people. We have, but the law does provide if there's willful, ongoing, intentional interference with visitation or parenting time of the other parent, then custody can be reconsidered. Getting custody reconsidered is a big deal. It isn't just something you can say, well, today I think I want it, so we're going to court. It's a hill you climb. And one of the ways to climb that hill is to say that I have had persistent and willful interference with my rights to have my child. I didn't get it for Christmas. I didn't get it for Easter. I drove all the way from Georgia to pick up my kid, and she took him to Minnesota. All of those things. But yeah, most of the time, to get that in front of a judge, you're going to wind up hiring a lawyer, most of the time. You don't have to. You can do it on your own. We see it. And I'll tell you this, when I have to go to court with a client who has interfered with parenting time, I hate it, because I know something's going to happen. And part of what can happen is they can go to jail. Part of what can happen is that they can pay fines or the fees of the other side, and that does happen. Part of what can happen is that their own time can be curtailed, and most assuredly, without question, even if I haven't given them a good enough lecture about life, and clearly I haven't because they're not listening, that judge is going to. So it is not, violating these orders is not something the court takes lightly. But you having a sheriff have somebody give a sheriff an old order and say, my kid is at a house where somebody's smoking, and they have to go and try and figure out whether that's a violation. I mean, it's a civil process that works better in the civil system. That's not, I'm really not appearing on that, but that is something in a problem that we have seen. I'm not sure that that's the solution. But most of all, what I just want to impart to you is that we have ways, the best interest of the child standards, of looking at, letting the court look at, and helping the court look at, how are we going to provide parents time? And those best interest statutes have been changed, are applied. We have all these, we have parenting investigators like Lisa Benjamin. We have other people who help in that process and make it work fairly well. Does it always come out the way somebody wants? No. And for Mr. Deeds, it's been a very long journey, but I don't think we changed the whole system in a way that isn't going to work for most people just because it didn't work with one person or two or three. I did ask the Department of Human Services if they could tell me how many equal custody kinds of arrangements they are seeing now as opposed to the last session, and it's doubled. The number that they are seeing orders, and they have their own way of figuring it out. Court orders that are applied now because of equal custody has doubled. Some of those come from a judge's decision after court trial. Most of them come from people's agreement. And when you have the question of who has presumed joint custody, equal custody, and who does not, I do get the family law quarterly, which competes with my husband's accountancy quarterly, or dullness. But in here, they list which states do some presumption of joint custody, and really, truthfully, there's just a handful. And it's a small handful that requires it unless you prove otherwise. Most of the time, what they say is, if we say that, if parents agree to it, we gotta have it. You gotta have it or you gotta prove something wrong. So everybody's agreeing, yeah, we can do it. But that's kind of going back to Australia, where the parents could cooperate, where the parents could work together, where the parents could parent, then that's what they were able to do. Because what happens with the cookie cutter 50-50, you will do that kind of time. What happens is you're making the children shoulder the burden of making this family work. Instead of saying, okay, you two just can't do it. We're gonna order it 50-50, we'll just let your kids figure it out. That's not really how it should be. And so I think that Section 4 should not go along. Now, there's more questions.
Thanks, Travis. Sherry, a parenting coordinator would just be a mediator. They would have no legal authority, right?
I think what I say is they're mediators with teeth. They can help people apply the court order and say, no, this Thanksgiving is his Thanksgiving because it says in odd numbered years, Dad gets Thanksgiving. You wouldn't think they'd have to do that, but that's what they can do. So to some extent, they're a little bit better than a mediator who can only say, let's do all this stuff and have all this communication, and then let's see if you can reach an agreement. So they have to be mediators or trained in it in order to be parenting coordinators, but they have a little bit more authority, although they cannot undo a court order.
Thank you.
I'm sorry, I didn't see Mr. Chairman.
Further questions from the committee, Representative Mooney?
Thank you, Mr. Chairman, and good morning. And it's a follow-up to Representative Anderson's question, which would be, so with teeth, does that mean then you have a situation that two parents can't agree, things are running out of amok and out of control, and this individual then has the ability then to initiate court proceedings, put them back into the position of having to have this dealt with?
Chairman, no, they can't initiate court proceedings. The idea is for them to help these people and tell these people how to do what they need to do to avoid the court proceedings, but it's still there if it can't work. So I know a parenting coordinator who has had to have the discussion of returning the clothes not soiled. Please, could you just return the boots? I got a call from her and the boots didn't go back.
Sure, but on more serious level issues.
Yes.
Is there actual real teeth in their ability to be able to help two parties come together